Dissolution of partnership firms. Legal position. A partnership firm is a business organization where two or more persons collectively form partnership with one another. Here, partnership is a relation between the persons who come together to share profits of the business. The business may be carried on by all partners or any one partner on behalf of other partners. A partnership firm, like any other business organization, can either grow or perish. Dissolution of partnership firm. In a partnership firm, sometimes there can be conflicts amongst the partners, and as a result, one of them may quit the firm. In such a case, the relation between the partners changes and partnership is dissolved, but the firm continues. Change in partnership agreement is termed as reconstitution of the firm. Also, due to the reasons such as death of a partner, retirement of a partner, insolvency of a partner, or admission of a new partner, there is reconstitution in a partnership firm. However, complete breakage of relation between all partners of the firm is called dissolution of the firm. After the dissolution of the firm no longer continue to exist. Section 39 to 43 of the Indian Partnership Act deals with dissolution of partnership firm. Dissolution of partnership versus dissolution of a partnership firm. Dissolution of partnership is different from dissolution of partnership firm. The Indian Partnership Act recognizes the difference between the dissolution of partnership and dissolution of partnership firm. Let us first understand dissolution of partnership. The breakage of relation between a few partners of the firm is called the dissolution of partnership. In this case, the relation between all partners is not broken down and hence the firm continues to function. As mentioned earlier in this lecture, dissolution of partnership occurs either when a new partner is admitted or the retirement or insolvency or death of an existing partner. This causes reconstitution in the existing firm. Reconstitution can be understood as the change in profit sharing ratio. For example, let us take case 1. John, David and Philip are three partners in a firm, Crystal Enterprises. If Philip retires, the partnership relation between John, David and Philip will come to an end, and Crystal Enterprises will continue to exist with reconstituted relation between John and David. If a new partner, Bob, is admitted into Crystal Enterprises, the firm will continue with reconstituted relation between three partners, John, David and Bob. Case 2. Assume the same firm, Crystal Enterprises, referred initially, with John, David and Philip as three partners in the firm. In case if the partnership between all three partners, John, David and Philip, comes to an end, it will result in dissolution of Crystal Enterprises. Now, modes of dissolution of partnership firm. Dissolution of the firm occurs in two ways. 1. Dissolution without the intervention of the court, and 2. Dissolution by the order of the court. There are 4 ways of dissolution without the order of the court. 1. Dissolution by agreement, refer to section 40 of Indian Partnership Act. 2. Compulsory dissolution. Refer to section 41 of Indian Partnership Act. 3. Dissolution on happening of certain contingencies. Refer to section 42. And 4. Dissolution by the notice of the partnership at will. Section 43 of the Indian Partnership Act. Now, what does dissolution by agreement mean? Section 40 of Indian Partnership Act stipulates that a partnership firm can be dissolved with the consent of all the partners of the firm or in accordance with the contract between all partners. A firm can be dissolved if all the partners of the firm mutually agree to dissolve the firm, or a firm can also be dissolved by an agreement or a contract between all the partners. Such a contract between the partners may be expressed or implied. Second, compulsory dissolution of a partnership firm. As per section 41, a firm is dissolved compulsorily in the occurrences: A. By adjudication of all the partners or all the partners except one as insolvent. The firm is forcibly dissolved when all or all except one partners of the firm are declared insolvent by the court. The partners cease to be a part of the business from the date on which they are adjudicated insolvent. For illustration, John, David and Philip are partners in the firm and John and David are adjudicated insolvent. John and David are prohibited to enjoy ownership rights in the business organizations. In the event of such happening, the partnership firm cannot exist with only one partner, Philip, as it violates the necessary requirement of a partnership firm, that a partnership firm must have minimum 2 partners to be called as partnership firm. A firm is dissolved compulsorily by happening of any event which makes it unlawful for the business of the firm to be carried on or for the partners to carry on in partnerships. For example, if a partnership firm is in liquor business and liquor prohibition is introduced by the government, the firm gets dissolved. But if the business is in 2 different ventures and one of them is declared unlawful, then the firm can continue with the business which is legal. The third way of dissolution is related to the happening of certain contingencies. The contingency of the fixed term of partnership contract, completion of ventures or death or insolvency of a partner. It is provided under section 42 of the Indian Partnership Act that if it is so mentioned in the contract, a partnership firm can also be dissolved under the occurrence of certain contingencies. A. If the firm is constituted for a fixed term, it is dissolved on the expiry of the term. B. If the firm is constituted to carry on one or more adventures or undertakings, then it is dissolved on completion of these undertakings. C. A firm is dissolved on the death of a partner, if so mentioned in the contract. D. A firm is dissolved on the adjudication of a partner as an insolvent, is so mentioned in the contract. 4. Dissolution by notice of the partnership at will. Section 43 of Indian Partnership Act lays down that when a partnership is at will, any partner can dissolve the firm by giving notice to all other partners of his intention to dissolve the firm. Type 2. Dissolution by the court. Now, we will study the manner in which a firm can be dissolved by the order of the court. Dissolution by the court is also called as dissolution by a decree or order of the court. Before we discuss this part, it is important to recognize that in case if partnership is at will, the approach to court is not necessary for the dissolution of the firm. Any partner can dissolve the firm by giving written notice to other partners. However, in case where the partnership is not at will, the court can intervene in the dissolution of the firm if any one of the partners files a suit. Under the provision of Section 44 of Indian Partnership Act, where the partnership is not at will, the firm can be dissolved by the order of the court if one of the partners files a suit. A. Insanity of the partner. B. Permanent incapacity of a partner. C. Misconduct of a partner. D. Persistent breach of agreement by a partner. E. Transfer of interest by a partner. F. Business working at a loss. G. Any other just or equitable ground. Now, let us understand each one of these in detail. A. Insanity. Under the provision of Section 44, subsection A, a partner can file a suit for dissolution of a firm on the ground that another partner other than the partner filing the suit has become of unsound mind. The suit can also be filed by the next friend or legal representative of the partner who has become of unsound mind. B. Permanent incapacity. A partner can file a suit in the court for dissolution of a firm on the ground that a partner other than the partner filing the suit has become in any way of permanently incapable of performing his duties as a partner. Such a suit is maintainable only when permanent incapability is supported by proper medical evidence. The court cannot pass an order of dissolution in case of temporary disablement. Refer Section 44, subsection P. C. Misconduct. When a partner other than the partner suing is found guilty of misconduct and such a conduct is likely to affect prejudicially the carrying on of the business, the court may dissolve the firm. Such misconduct need not be connected with the business of the firm. It is sufficient if it affects the carrying on of the business. For example, if a partner is guilty of immoral acts or fraud outside the business, it is implied that due to his behavior, his reputation and therefore the reputation of the firm will suffer. Let us understand this incidence. A and B were partners in a business. B was convicted of travelling on a railway without ticket with fraudulent intentions. Held as conviction for dishonesty, it was detrimental to the conduct of the business and it was sufficient ground for dissolution of the business. Now, this is cited from Carmichael versus Evans 1940, chapter 486. D. Persistent breach of agreement. A firm is dissolved by the court on the ground of persistent breach of agreement by one partner. When a partner other than the partner filing the suit willfully or persistently commits breach of agreements relating to the management of the affairs of the firm or conduct of the business, in such a case the court may dissolve the firm. The court can also dissolve the firm if a partner conducts himself in such a way that it is not reasonably predictable for the other partners to carry on the business in partnership with him. Refer Section 44, subsection D. E. Transfer of interest by a partner. In this case, a partner can file a suit of dissolution on two grounds. One, on the ground that a partner other than the partner suing has transferred the whole of his interest in the firm to the other party. 2. On the ground that a partner has allowed his share to be charged under execution of a decree against him under the provision of Rule 49 of Order 21 of the first schedule of Code of Civil Procedure 1908. A court can also dissolve a firm if a partner has allowed his share to be sold for arrears of land revenue or for charges recoverable as land revenue. All suits should be filed by any partner other than the partner who has transferred or charged his interest in the firm. Refer section 44 subsection E. This law is justified on the premise that if a partner has transferred his interest to a third party or sold his share to a third party, the partner's interest in business will naturally suffer, and the other partners in the firm may lose faith in the partner who has transferred or sold or charged whole of his interest. Further, the third party who now gets interest in the firm may not be acceptable as a partner to other partners. Hence, in such a case, dissolution of the firm is maintainable. On the contrary, if the transfers of the interest to third party with the consent of all other partners, naturally the suit for dissolution is not maintainable. In other words, the court cannot order the dissolution of the firm. Next, if business is working at a loss. In case of loss-making firm, the court can pass an order for dissolution of a partnership firm if the business cannot be run except at a loss. A suit for dissolution of the firm should be filed by a partner. In such cases, the court can dissolve partnership firm even if it is established for a fixed period. Refer section 44 subsection F. G. The court can order dissolution of a partnership firm on any other just and equitable grounds. This is explained in this section. Under the provision of section 44 subsection G, a partner in a firm can file a suit for dissolution on any other ground which renders it as just and equitable that a firm be dissolved. In this case, the court should be satisfied that the reason and the situation is such that the continuation of a firm is impossible or impracticable. We can mention instances where firms have been dissolved in the past under the provisions of this section. The firm was dissolved where there was a deadlock in the management, that the very basis or foundation of the business has disappeared, or where the partners were not on speaking terms. Consequences of dissolution of the firm. A partnership firm conducts business in external environment and is accountable to various stakeholders. After the partnership firm is dissolved, the business is wound up and proceeds are distributed amongst the partners. Although the firm has been dissolved, the partners still have the rights and have to perform duties as former partners. Now, we discuss the rights and liabilities of the partners on dissolution of a firm. Rights of a partner on dissolution. On the dissolution of a partnership firm, a partner has rights. 1. Right to enforce winding up. Refer section 46. On dissolution of the firm, every partner or his representatives has the right to apply the property of the firm for payment of debts and liabilities of the firm, and if there is surplus, if any, it is distributed among the partners or their representatives in accordance with their right. The right of the partner is called a partner's lien. 2. Right to settle the debts of the firm out of the property of the firm. Refer section 49. Section 49 of the Partnership Act lays down that where the firm is dissolved, the debts of the firms are settled out of the property of the firm, and if there is any surplus, it is utilized towards the payment of private debts of the partners. As regards the private debts of the partners, his private estate is first applied in payment of his private debts, and if there is any surplus, the property of the firm is applied towards the settlement of his private debts. 3. Right to personal profits earned after dissolution. Refer section 50. Where a partner has bought the goodwill of the firm on its dissolution, he has the right to use the firm's name and earn profits by its use. 4. Right to earn premium on premature dissolution. Section 51. Sometimes a person pays a premium for joining in a firm as a partner for a fixed term. In such a case, if the firm is dissolved before the expiration of the term, the partner is entitled to the repayment of the premium, in part or in full, depending on conditions. 1. The terms upon which he became a partner. 2. The length of the time during which he was a partner. However, the partner who had paid the premium cannot claim any refund on dissolution. 1. Though prematurely, if dissolution is due to the death of a partner, and 2. if the dissolution is mainly due to the misconduct of the partner who has paid the premium. 3. Is on pursuance of an agreement which contains no provision for the refund of the premium or any part thereof. 5th, right where partnership contract is rescinded or annulled for fraud or misrepresentation. Section 52. Section 52 of the Indian Partnership Act lays down that where the partnership contract is cancelled on the ground of fraud or misrepresentation of one of the partners, the other partner is entitled to repeal or cancel has the rights, namely, right of lien on the surplus assets. He has the lien on the surplus of the assets after the debts of the firm have been paid for any sum paid by him for the purchase of his share and for any capital contributed by him. Right of subrogation. When a partnership firm is forcibly dissolved due to fraud, the partnership creditors are entitled to receive repayment of the debts paid towards the firm. In such a situation, if a partner pays off any of the creditor out of his own pockets, he steps into the shoes of that creditor, means he becomes a creditor to the firm for that amount. Right to be indemnified. He also has the right to be indemnified or covered by the partners guilty of fraud or misrepresentation against all the debts of the firm. 6. Right to restrain partners from use of firm name or property. Section 53 of the Partnership Act lays down that after the firm is dissolved, none of the partners have the right to carry on any business in the firm name. To state in specific words, Section 53 of Partnership Act stipulates that after the firm is dissolved, any partners or his representatives may restrain any partner or his representative from carrying on similar business in the firm name or from using any of the firm's property for his own benefit until the affairs of the firm are completely wound up. However, these restrictions do not apply in the two cases: A, where the contract is between the partners on the contrary; B, where the partner has bought the goodwill of the firm. Liabilities of a partner on dissolution of a firm. 1. Liability for act of partners after dissolution. Section 45. Under the provision of Section 45 of Partnership Act, after the dissolution of the firm, public notice must be given of the dissolution. Public notice is necessary to absolve partners of the liability for any act done after dissolution of the firm. Notwithstanding the dissolution of the firm, the partners continue to be liable as such to third parties for any act done by any of them which would have been the act of the firm if done before the dissolution, until public notice is given of the dissolution. Refer Section 45, subsection 1. Public notice under subsection 1 may be given by any partner. Section 45, subsection 2. For example, A and B are partners in trade, agree to dissolve the partnership. They execute deed for that purpose, declaring partnership dissolved as from January 1, 2015, but do not discontinue the business or do not give public notice of dissolution. On February 1, 2015, A endorses a bill in the partnership name to C. The firm is liable on the bill. Continuing authority of partners for the purposes of winding up. As stipulated in Section 47, after the dissolution of the firm, it is continuing authority of each partner to bind the firm. They have the other mutual rights and obligations as partners of the erstwhile firm. They have the right to A, wind up the affairs of the firm; B, to complete transactions began but unfinished at the time of dissolution. Settlement of accounts. After the firm is dissolved, the accounts need to be settled. The final accounts of each of the partners of the firm are settled according to the accounting clause provided in the deed of partnership. In case such provisions are missing in the partnership deed, the provisions made under Section 48 apply. 1. Sale of goodwill. The firm in the course of its existence has earned goodwill for its name and it can be valued. On dissolution, while settling the accounts of the firm, the goodwill can be included in the assets and it can be sold separately or along with the property of the firm. Refer Section 55, subsection 1. 2. Application of assets. All the assets of the firm will be applied: 1. In paying the debts of the firm to third parties; 2. In paying to each partner ratably what is due to him from the firm for advances distinguished from capital; 3. In paying to each partner ratably what is due to him on account of capital, and the residue, if any, shall be divided among the partners in proportion in which they were entitled to share profits. Refer Section 48, subsection B. If the assets are sufficient to pay 1 and 2, that is for repayment of debts to third parties and for repayment of advances from the partners, but insufficient to repay to each partner his share of capital, then the deficiency in the capital shall be borne by the partners in proportion to their profit share. For example, P, Q and R are partners, the firm on the terms that profit should be shared equally. The capital was contributed in unequal shares, the capital contributed by P being more than the capital contributed by Q. On dissolution of the firm, after satisfying all the liabilities to creditors and advances to partners, the assets were insufficient to repay the capital in full. On the ground that all three partners were equal profit sharing ratio, each partner is liable to contribute an equal third share of deficiency and then to apply assets in paying equally, that is, ratably his share of capital. 3. Losses must be paid first out of the profits of the firm, then out of the capital, that is, the amount already invested by the partners in the firm. Limitation period. The limitation period for filing a case in the court in regard to settlement of firm's account after dissolution is 3 years. So, if a partner fails to file such a case against even one partner within this period of 3 years, the whole claim gets barred against the remaining partners as well. Lay down that a public notice has to be given 1. On the retirement or expulsion of a partner, 2. On the dissolution of a registered firm, 3. On the election to become or not become. Public notice. Public notice should be given on dissolution of a partnership firm. 1. By notice to the registrar of firms, 2. By official gazette. 3. By publication in at least one vernacular newspaper circulating in district where the firm has its principal place of business. If notice of dissolution is not given, the partners shall continue to be liable to third persons for any act done by any of them. Let us summarize. Dissolution of partnership. Dissolution of partnership occurs when, for certain reasons, the partnership relation does not continue between any two partners in the firm. According to section 39 of Indian Partnership Act, the breakdown or cessation of relation between all partners of the firm is called dissolution of partnership firm. Dissolution of partnership is different from dissolution of partnership firm. Dissolution of partnership firm can occur with or without the order of the court. Dissolution without the intervention of the court can happen by any of the means. A. By mutual agreement between the partners. B. Compulsory dissolution. C. Dissolution on the happening of certain contingencies. D. Dissolution by notice if the partnership is at will, as provided in sections 40 to 43 of the Indian Partnership Act. Dissolution by the order of the court, as stipulated in section 44 of Partnership Act, can take place on these grounds: A. Insanity of the partner. B. Permanent incapacity of a partner. C. Misconduct of a partner. D. Persistent breach of agreement by a partner. E. Transfer of interest by a partner. F. Business working at a loss. G. Any other just and equitable grounds. Next, consequences of dissolution. On dissolution, the partners have certain rights and liabilities on behalf of the firm. Rights of partners are: 1. Right to enforce winding up, section 46. 2. Right to settle the debts of the firm out of the property of the firm, section 49. Settlement of accounts. On dissolution of the firm, the final accounts of each partner are settled as provided in the deed of partnership or as provided in Section 48 of the Partnership Act. The accounts are settled with respect to sale of goodwill, application of assets and distribution of losses. Thank you.